noticed, I think I'm correct, I think I read that the UK has actually started proceedings against the EU for squeezing us out of the scientific cooperation programmes. And they're right to do that, because the EU has no right to take any kind of sanction against us. But
please tell me you guys haven't been hanging around waiting for me to start
really, this isn't
live
a legal
streaming.
problem at all. It's a political problem. The people in Brussels don't want us to do it. The man in the White House doesn't want us to do it. Surprise, surprise. But they haven't got a legal argument that they can use. Theirs is a policy argument. And our response is we're entitled to do it. And that, or our response should be, we're entitled to do it under Article 16. But nevertheless, politicians.
Dear. Oh, I do apologise. You. Has this live stream just started, or has it been going on for an hour? All right, cheers, thanks for that. Because if I'm honest, I was just having a little look at certain things, and I was thinking, oh, thank God for that. Cheers. I had visions of me doing this for about a bloody hour. Right. Right, yeah. What, just started now? So it's like so I've been looking at one or two of the oh dear. See, the thing is, I was under the impression that I pressed the thing on the what they call it on the OBS, and I was under the impression that I've been chuntering to myself for an hour. Oh dear. Do you know what? I'm a complete bell tap. Oh. Right. So right, we have a choice here. I can quite easily, it's like the thing what I've been doing. Oh dear. Right. Right, we have a plan. Right. I can quite easily put this. I've been watching this on my Jack Jones, and it's practically nearly finished. What a tit I am. Oh, what a clown I am. Right. What do you want to do then? Do you want me to put it back up? Yes, I'm doing a GB News tribute channel. Yes. I'm not quite Nigel Farage yet, but what I did. As I say, I'm still learning my ropes and all that. When it comes to sorting it out on the YouTube, you've got to press the start stream on here first as well. Oh. So I've been babbling on like a complete bell tap for a good hour. And the guy who, yes, Anne Widdicombe. So I could quite easily put this back to the start and we could watch it now, or do you want to do something else? So it's up to you. We can mess about for about an hour or so, you know. Right, I'll rewind. Right. Now let's get... Right. I'm not going to just go through the old rigmarole because just waste time. So what I'll do is, this is the second part, and these two are legal experts, and what they have to say is very, very interesting. So let's get on with it before I make a complete mess of it all again. Right, enjoy.
Northern Ireland. We are continuing our new inquiry into the Northern Ireland Protocol Bill with a second panel of witnesses consisting of legal experts. Professor Alan Boyle, Emeritus Professor at Edinburgh University and Essex Court Chambers, is joining us in person. And Professor Mark Elliott from the University of Cambridge is joining us remotely. You are both extremely welcome, and we very much look forward to your evidence to us. Perhaps I could ask you to introduce yourselves briefly the first time you speak. Today's meeting is being broadcast, and a verbatim transcript will be taken for subsequent publication, and we'll send that to you both to check for accuracy. And I refer to the list of members' interests as published on the committee's website. So welcome to you both, and perhaps I could ask each of you just to introduce yourself briefly. Perhaps I could start with you first, Professor Boyle, as you're with us, and then go on to Professor Elliott. But if you could just introduce yourself, and then I'll ask the first question.
Well, thank you, Lord Chairman. It's a pleasure to be here. It's the height of every barrister's career used to be to appear in the House of Lords, and I finally made it. But
in this room.
I am fundamentally an academic. I've spent 40 years at London University and at Edinburgh and in various other universities, teaching mainly international law, but also constitutional and public law. And I've written a great deal on international law, obviously. But shortly before I retired, I started practicing again as a barrister, and so I've now got quite a lot of experience in the International Court of Justice and the Tribunal of the Law of the Sea. So I do a lot of interstate disputes, and in a way I view this as an interstate dispute. It's a case that hasn't yet happened, but that might still happen. But it's at a stage which is not dissimilar from many of the clients I represent, because you come in early on and there's an impasse and people don't know how to get out of it. And usually the answer is, well, you should go and talk to the other side. And I think that's probably the essence of what I would say. But anyway, I don't know what else you'd like me to say.
I think that's fine for now. Thank you very much for that introduction. And perhaps, Professor Elliott, perhaps you could introduce yourself too.
Well, thank you very much for inviting me. I'm a professor of public law at Cambridge University. I'm not an international lawyer, and so I think that on some of the points that you want to raise today, Professor Boyle will be better placed than I am to comment. But I do take a close interest in the legal issues around the UK's departure from the EU, and I've written quite a lot about this, and so I hope I can help with at least some of the questions that you might have.
Well, thank you very much. Thank you very much, both of you. Perhaps I could just start by asking you both, really, what you would identify as the principal legal issues and consequences arising in relation to the Northern Ireland Protocol Bill. Perhaps we go the other way around. Perhaps, Professor Elliott, I could ask you to start on that, and then Professor Boyle.
Thank you. So I think that my general view is that while the bill obviously tries to address a practical, an economic, and a political difficulty, I do think that there are some legal difficulties with the bill as it currently stands. I think fundamentally it seems to me that there is a good argument, at least, that there is an incompatibility between the bill and the provisions that lie at its conceptual heart, as I would see it, and the obligations by which the UK is bound under international law through the UK-EU withdrawal agreement. So would you like me to expand on that now, or would you like to come back to the points of detail?
I think we'll probably come back to them as we go through the evidence, but if at any stage you feel that we haven't asked you things we should have asked you, I'm sure you will, you'll tell us anyway, and we'd certainly hope for that. Thank you. Professor Boyle.
Well, thank you. I think what Professor Elliott just said is interesting, because I'm not an EU lawyer, and that might be my weakness. He says he's not an international lawyer, but he is an EU lawyer. Okay, so I haven't studied the withdrawal agreement in any great depth. But the key point, I think, I've read lots of politicians here and in Europe saying, oh, this protocol violates international law. I haven't heard a single one, nor have I read anybody explaining in what respect it violates international law. It doesn't violate international law, put in those terms, not in the slightest, unless it violates the withdrawal agreement or the protocol itself. But for me, the bill can be justified in terms of Article 16, the derogation provision. And if you can justify it under Article 16, then it cannot be a violation of the protocol, and it cannot be a violation of the withdrawal agreement. And I quoted a passage from a Law Journal article in the copy of my text that I sent round, and the author of that article, who has looked at the withdrawal agreement and all of the relevant EU treaties, comes to the same conclusion as I have. Indeed, I have adopted her conclusion that there is no incompatibility between the bill and any of the international treaties by which the UK is bound, provided, and this is the key proviso, provided the government can justify its derogations in terms of Article 16. Now, I don't see a difficulty in doing that. I think the collapse of government in Northern Ireland, devolved government in Northern Ireland, is a societal difficulty. And the protocol, part of its purpose, was to sustain power sharing under the Belfast Agreement. Well, yes, it hasn't exactly succeeded in that, has it? And it seems to me that the government's purpose is to try and restore power sharing, and that's consistent with the objective of the protocol, and I think the government is entitled to pursue that objective, and I don't have any difficulty with their derogations in terms of Article 16. Let me put it this way. I would be happy to defend those derogations in an arbitration. It wouldn't be very difficult. I would be lost for arguments if I were on the other side trying to attack them. So I'd be interested to hear what Professor Elliott says and whether he fundamentally disagrees with me. But anyway, that's all I would say about international law. Either we're okay under Article 16 or we're not, but that's the only legal issue that arises. There is no other basis for saying that there's a breach of international law.
Well, we'll come back to come on to Article 16, which is an interesting question. We'll come on to that in a moment or two. Meanwhile, Baroness Ritchie.
Thank you, Lord Chair. And I'll go first to Professor Boyle. What is your assessment of the government's legal position on the Northern Ireland Protocol Bill as set out on the 13th of June 2022 policy paper? And then I'll come to Professor Elliott. So, Professor Boyle.
Well, fundamentally, I can see where they're coming from. They're trying to restore power sharing. And I think they're doing it in a way which is consistent with Article 16, but where I have problems is, well, with the former Foreign Secretary, now her Prime Minister. She keeps saying that she doesn't want to use Article 16. She wants to rely on the international principle of necessity. I think this is nonsense. The international principle of necessity has no place in this debate or discussion. The focus should be on Article 16. I can't understand why she didn't want to rely on it. So if her legal position is to try to avoid Article 16, then I think she's basically sunk. Because if she refuses to rely on Article 16, if she won't serve the derogation notice and engage in the consultations envisaged by the appendix, I think it's Appendix 7 of the protocol, but there is a procedure there. If she won't engage in that, if the government won't engage in that, then they've had it. But if they will engage in it, if they will locate their defence in Article 16 and the restoration of power sharing, then I think they have a very strong case indeed. And the European Commission would be lost for decent arguments, in my view.
Thank you. Professor Elliott?
Thank you. So I don't think that the distance between Professor Boyle and I is very great at all, really. In my initial answer, when I said that I thought there was some difficulty with the bill, that was really premised on the government position that Professor Boyle has just outlined, namely that it doesn't propose to rely on Article 16. So if we take that at face value, and if Article 16 is not invoked, then it seems to me quite clear that the protocol will place the UK in breach of its obligations under the withdrawal agreement. If I can just refer to a couple of key provisions of the withdrawal agreement, of which the protocol is, of course, a part. Article 4 of the withdrawal agreement itself specifically requires the UK to give effect in its domestic legal system to relevant parts of the agreement, including the protocol, in the same kind of way as we used to have to give effect to European Union law, and that means effectively allowing relevant provisions of the protocol and other parts of the agreement to have what EU lawyers call direct effect and primacy. And all of that was catered for through the EU Withdrawal Agreement Act 2020, which writes into the Withdrawal Act of 2018 provisions that give that special legal status to the withdrawal agreement, including the protocol. And I don't think that there can be any room for argument that the Northern Ireland Protocol Bill rides roughshod over that regime by specifically excluding parts of the protocol from that regime and stopping it from having domestic effect, stopping it from taking priority over domestic law, and stopping UK courts from enforcing it. So I think that there are very clearly specific provisions of, and indeed the whole legal scheme of, the withdrawal agreement with which the Northern Ireland Protocol Bill is incompatible. So it seems to me that the only real question is whether, notwithstanding that obvious incompatibility, which I think the government accepts exists, it must accept it exists, because otherwise why would it be relying on reasons for justifying the departure from the protocol? Once we recognise that that's the focus of the issue, the only questions are whether there is any legal basis for departing from the protocol. Now, on the Article 16 point that Professor Boyle has mentioned, I agree that does provide a possible escape route. But one thing that I would draw particular attention to is that Article 16, unlike the international law doctrine of necessity, doesn't simply lay out certain criteria which, if the UK thinks they're satisfied, allows it to deviate from the protocol. Rather, it lays down a process which is set out in Annex 7 to the protocol that the UK would need to trigger before Article 16 would provide a legal basis for departing from the protocol. I think the bottom line is that unless the UK is willing to go through that process and trigger that process under Article 16 and Annex 7, there's no conceivable way in which Article 16 can provide a legal basis to reconcile the bill with the UK's existing obligations under the withdrawal agreements and the protocol.
Thank you.
And if I may say so, I agree with every word of that. I think we're exactly on the same page. But the only thing I would also add, and it's relevant here, I don't see why the government hasn't already activated that procedure, why they haven't already served a derogation notice on the EU, setting out its derogations, entering into the consultations that are required. They don't need to wait until the bill is passed. As a matter of simple treaty law, they can derogate now and legislate subsequently to change the domestic law. As a public international lawyer, if I were asked, that's what I would advise them to do. And I don't understand why they haven't done it. I can understand why they've paused the bill. I can't understand why they haven't, therefore, served a derogation notice. Then they can sit back and wait if they want. But derogate now, and they're no longer violating the protocol.
Thank you.
Very interested, isn't it? I think there must be maybe the Article 16 isn't going to give them, the government, what they want. I think that looks pretty obvious, doesn't it? I'd like to say these two don't understand why they haven't. So I found that conversation fascinating.
Thank you. Lord Hayne, should we move to you?
Thank you for your evidence so far. Given that the bill has been introduced without the agreement of the Irish government, without the agreement of any of the parties save for one, how can it be compatible with the Good Friday Agreement, since the government is saying its reason for introduction is to safeguard it? Perhaps I could start with Professor Elliott.
Well, I think that I have a general difficulty with this line of argument. I mean, I understand why.
I mean, my question, or the government's.
The government's, not with your question. I mean, of course, I understand that there is, that there is room to argue that if the situation in Northern Ireland is so problematic, that it risks, or that it creates some kind of existential threat to the political institutions of Northern Ireland. That clearly places the values underpinning the Good Friday Agreement in jeopardy. But when you look at the government's legal position paper, which we've just been talking about, what we find in there really are very thin assertions about the circumstances. Now, I don't feel qualified because I don't know enough as a lawyer. I don't know sufficient about the situation politically and economically in Northern Ireland to really have a concluded view. But I do worry that that sort of using the Good Friday Agreement as cover for doing this is clearly a politically expedient thing to do. But I'm not convinced that it holds a great deal of water. I would also just add as a side note that if I'm right in suggesting, in effect, that the government is invoking the Good Friday Agreement strategically or politically, that view is backed up by the position that they have taken in relation to the Good Friday Agreement and the European Convention on Human Rights. I'm aware that this afternoon the government has signalled that its current Bill of Rights is to be withdrawn. But in the wider debate about human rights law, the now Prime Minister told the Conservative Party leadership hustings in the summer that she was open to the possibility of withdrawing from the European Convention on Human Rights, which would be a clear breach of Strand 1 of the Good Friday Agreement. So I think my underlying concern is that the government is picking and choosing, and it's invoking the Good Friday Agreement when it suits it. But when you look at its legal position paper in relation to this bill, its arguments are very sketchy.
Thank you. Professor Boyle.
Well, I have to say I am Northern Irish. I left Belfast to go to Oxford in 1972 when the place was in a civil war. On a daily basis, I could see bombs going off. I went into school one morning, and the front door was riddled with machine gun bullets, and I didn't want to go back, and my dad didn't want me to come back. And I was back recently at my school and in Belfast, and the place is what it was like when I was a boy, when I was a little boy. It was jolly, it was calm, it was peaceful, it was relaxed. It was what Northern Ireland used to be like, and the transformation was unbelievable. Well, the Belfast Agreement has done what nobody had managed to do in 100 years, bring peace and semi-civilized government. You will have experienced something somewhat similar yourself from your own political background, but bringing the communities in Northern Ireland together to give them the responsibility of ultimately governing themselves is a nightmare, has been a nightmare for everybody in the past 100 years. But the Good Friday Agreement has brought real progress, and I have to say, I would not vote for or tolerate any politician who said we should risk that wonderful achievement. In Northern Ireland's 100 years of lamentable history, the Good Friday Agreement and power sharing is the only decent achievement of the whole thing. The first time my mum and dad went to vote was when, as a teenager, I persuaded them to go and vote for Terence O'Neill and his Ulster at the Crossroads election, because he was trying to change the place. He was trying to do what the Good Friday Agreement does. He was brought down. But I can't see any future for Northern Ireland without power sharing. So I'm absolutely with the government. If they want to do whatever is necessary to keep power sharing under the Belfast Agreement going. Now, I would take that further. One of the fundamental problems of the protocol is it was imposed on Northern Ireland without anybody bothering to ask the Northern Irish in any form whether they wanted it. It's a sort of colonial exercise. At some point, both Westminster and Brussels have to grasp that we have devolution in the United Kingdom. There are 4 nations with 4 parliaments and 4 governments, and we need to function. Westminster needs to function in a way which brings those on board instead of dictating.
What about my specific question on the legalities?
I'm sorry? Well, the objective, it seems to me, to be one that is supported by the protocol. You read the preamble of the protocol, it's there, it declares that part of its objective object and purpose is to support power sharing under the Belfast Agreement. Now, that's fundamental to interpreting Article 16. You cannot extract Article 16 from the context, and the context is the Belfast Agreement, and the Belfast Agreement is power sharing. So that's why I think what the government is doing is lawful. And that's what I would say if I had to stand up and argue the point. It's that object and purpose, I think, that would be crucial. Now, you could ask, is the government going too far? Well, I've considered that one. And here's the difficulty. We're trying to get the DUP to go back into office. Well, I'm not the DUP. I have no contacts with the DUP. I don't know what their terms are for going back into power sharing. Somebody would have to ask them. But I can only assume that what is in the bill reflects what the DUP have said would bring them back into power sharing. I mean, I would much rather the Northern Irish parties all got together and decided for themselves what the right outcome should be, and I think that is the ultimate solution.
You all would.
Yeah, and I think actually my wife drew my attention to some article or speech by the new Prime Minister today, and I think she seems to want something not dissimilar from that. And if that is her thinking, then I think she's right. But the politicians in London and Belfast, and to some extent Brussels, have to get together and come up with a solution that they can all agree on. Otherwise, it'll collapse again. There's no point the UK and Brussels coming up with yet another dictated solution. Otherwise, the Northern Irish will bring that down.
Thanks very much. Yeah.
Thank you very much. Thank you. Baroness Gowdy.
Good afternoon. Thank you. Professor Elliott, what is your assessment of the EU's response to the publication of the bill, including recommencement of paused and launching new infringement proceedings? And further, what remedies is the EU likely to pursue, and what would the consequences, or should they do so?
Well, of course, it's important to remember, obviously, that the bill is only a bill at this stage. And so I suppose, there is, of course, an argument which has been advanced that merely to promote the bill is a breach of good faith requirements laid down in Article 5 of the withdrawal agreement. But I think that the fact that the enforcement action has been undertaken in the light of the bill is really an example of the wider political implications of the bill. I think the political wisdom, the diplomatic niceties of whether it's sensible for the EU to proceed in that way, and how it might be sensible for the UK to respond is again, really beyond my remit as a constitutional lawyer. But I think all I would say is that if the UK signals its willingness to play fast and loose with its obligations under the withdrawal agreement, it can hardly be surprised if the European Union responds in this kind of way. And I think that raises a broader point, really, which is that this does raise significant wider and reputational issues for the UK, and it will inevitably shape how other actors on the international stage deal with the UK. Now, if it's the case, as Professor Boyle has said, that actually all of this can be covered off under Article 16, and that puts a different complexion on things. But I would go back to my earlier point that not only has Article 16 not been invoked, it requires a process to be gone through, which the government has so far shown no interest in engaging in. And I think it can't really complain that the EU has chosen to avail itself of legal processes that the agreement does provide for.
Thank you very much. That's very helpful.
Mr. Boyle.
Can I just add, the infringement proceedings, of course, are because the protocol is still in force. We haven't derogated yet, so obviously we're in violation of it. And again, I come back to the point that Professor Elliott made. Why haven't we already deposited our notice of derogation? I think that would get us out of any future proceedings. But there have been some people suggesting that the EU might challenge the bill itself. I can see no basis for doing that. But when it comes back to Article 16, if we are acting lawfully, then there's nothing the EU can do. They can't suspend scientific cooperation. They can't suspend the trade and cooperation agreement. They can't impose any other kind of sanctions. This is all covered in that article in the ICLQ that I cite in my text. And the author of that has been through this in considerable detail and also looked at it in the context of comparing it with other trade agreements. But the fundamental point she makes is that there's nothing the EU can do unless we're acting unlawfully. If we're acting lawfully and the EU tries to impose sanctions, then they're acting unlawfully. And we're not breaking international law. They would be.
Well, that takes us on, I think, Lord Godson, to Article 16. Over to you.
Just before I let him answer his question, I found that very interesting. What do you guys think? Very interesting. self-of-a-press book.
I just wanted to sort of open, just because my curiosity was piqued by Professor Elliott's contribution, and now, just if I may, my Lord, deviate a little from the order of batting. How you referred to this whole debate, discussion would affect how actors viewed the UK in future in the wider international context. I just want to be clear which actors you were referring to there, so the committee had a full understanding.
I think that, well, I think I had in mind, obviously, most immediately the EU itself. But I think I also have in mind other states with whom the UK may want to enter into treaty relationships. But I think my point really is that as things currently stand, the government has signalled its intention to depart from the protocol and the treaty obligations in it. It has signalled its intention to, I think, to ignore the mechanism laid down in Article 16 for dealing with issues of this nature. And it has instead relied on an argument which I think Professor Boyle and I agree is entirely untenable, and which almost any lawyer you talk to thinks is entirely untenable, based on the international law doctrine of necessity, which I think clearly doesn't apply here. And so the picture which I think that paints is of a government that is willing to pay relatively little attention to its international obligations, and to dispense with treaty commitments when it feels that that's politically expedient. And I would have thought that just as a commercial party may look at a commercial counterparty that plays fast and loose with its contractual obligations and think twice about contracting with it, other states will be aware of the stance that the UK has taken on this matter.
Thank you. Can I just ask Professor...
Well, if I could just...
Or yes, Professor Boyle. Forget
well, if
please
I could
go
just
ahead.
observe. Very few treaties have derogation provisions in them. The European Convention on Human Rights does, and indeed we have derogated in relation to Northern Ireland in the past successfully. The GATT agreement does, but they're most unusual. And pacta sunt servanda, but what is the pactum? Article 16 is part of the pactum, and if we're complying it, then we're not breaking our treaty obligations. At the House of Commons Committee, someone put to me the proposition of, would we not lose our reputation for complying with international law? To which I had two answers. One, well, on my view, we would be complying with international law if what we do is justifiable under Article 16. But I also pointed out we don't have a reputation for complying with international law. We invaded Iraq in violation of the UN Charter. We don't have a reputation for complying with international law or sticking by our treaties. The General Assembly has condemned us twice in the past 20 years for violating our treaty obligations.
Can I just follow up just whether you're in with Professor Elliott on the whole question of necessity? Do you agree with his view on the UK government's invocation? Professor?
I'm sorry. Yes, I entirely agree. I think I've had the same conversations with international lawyers. They all laughed, and I can absolutely see where they're coming from, because it doesn't fit the parameters of the principle as set out by the International Law Commission. Well, protection of vital interests, yes. I can see that fits, but there are other problems if you look into the commentary. There's a problem about foreseeability of the problem. Well, yes, obviously the negotiators of the protocol foresaw that there would be problems. That's why they put Article 16 in. There's also the problem that with Article 16 there, why would you want to rely on necessity? I mean, if if I were the arbitrator, the first question I would ask counsel is, why are you relying on necessity? Why are you not relying on Article 16? At that point, counsel would have no option but to abandon the necessity argument. So it just doesn't work doing it that way.
Thank you, Melo.
Lord Hannon, I think...
just a supplementary, it's really for Professor Boyle, but Professor Elliott is very welcome to come in. I think the government, in response to the point that you've just made about Article 16, would say that it was insufficient, that it didn't build on a solid foundation the legal framework that they want for the dual regulation, the red and green channels, the new system of arbitration, and that therefore it would be open to, that those things will be open to legal challenge unless there is primarily legislation. I wonder if you would be kind enough to address that point.
Well, yes, but that doesn't mean the challenges would win. I'm no expert in trade regulation, but I thought what they'd done was a reasonable attempt to try and satisfy the EU's concern for its internal market. I mean, the protocol has two objective purposes. One is to sustain the Belfast Agreement, and the other is to preserve the EU's internal market. Well, as I read the bill, I think it's trying to balance both of those objectives. Whether it will do so successfully over time, who can tell? But there is a consultation procedure. There is a joint committee. If the EU is worried, it can derogate or it can bring legal proceedings. But, there is an assumption there that the parties will cooperate.
But to be clear...
Just start with good evening, Catholic. What is said about government trying to do their best to with the European Union and the Good Friday Agreement. Do you agree? I'm not sure I do, but there's far more intelligent people in the chat that'll either agree with me or disagree with me. But I'm welcome to hear what you have to say. I'm not sure. I'm not sure if I agree with what you just said there.
Do you think that the things that are proposed in this legislation could have been done under Article 16? That would have been a sufficient mechanism?
Yes. Yes. And I would have thought a derogation notice would say more or less what's in the bill. Now, I can't guarantee that for everything. I'd be a dumb lawyer if I were to say I can guarantee everything is hunky-dory. That'll be something that might be problematic. But fundamentally, the architecture of the bill sets out, as I see it, I think 5 derogations, and I think they can all fit with the objective of restoring power sharing in Northern Ireland, dealing with the societal difficulties.
Perhaps then I could very briefly put the same question to Professor Elliott. Do you think would you concur that the bill could have been done under Article 16, the effect of it could have been done under Article 16?
So I think that my assumption had been that the one that you outlined at the beginning of your question to Professor Boyle, that the reason why the government, or a potential reason why it had chosen not to go down the Article 16 route, was because it wasn't confident that Article 16 would cover the full range of things that it wanted to do. That might be in terms of the extent of the derogations, but I think perhaps it might also, or instead be, because as I've said in answer to previous questions, Article 16 is a process. It's not a magic wand that as soon as you invoke it, you get out of jail free. And it's an ongoing process. So I refer to Annex 7 to the protocol, which lays down the process. And it isn't that once you exhaust the process, you can derogate. The position is that there has to be consultation every 3 months, for instance, in an ongoing process. And so the general tenor of Article 16, as I read it, is that departing from the protocol is not just an exceptional course of action, but that it's implicitly assumed to be a temporary set of circumstances pending the stabilisation of whatever issues triggered its application in the first place. So I don't think I disagree with Professor Boyle that the language of Article 16 provides significant scope for doing things of the kind that the bill envisages. I suppose the attractiveness to the government, if the argument worked, of using necessity is that it is more of a get out of jail free card, that once you've shown that sort of hurdle has been cleared, then you don't have these complications of an ongoing process which Article 16 envisages.
Yes, I would fully agree with that, and I would only add one small point, but it's important. I mean, one might ask the question, can we say that everything in the bill is necessary for restoring power sharing in Belfast? Well, I can't answer that. Maybe the DUP can answer it. But that's where I think there is a weakness. But also, let's not pretend that we don't read the newspapers. I certainly do. And, you know, what the newspapers say is that there are Brexiters in the Conservative Party who have wanted things to be in the bill that may not be necessary for the restoration of power sharing. Now, there you have a problem. You know, how could I or any other council stand up in an arbitration and defend those bits of the bill if they're not necessary for the restoration of power sharing? Answer, you couldn't. So you've got to ask, are these derogations necessary? And it would be interesting to hear from the DUP at some point, not those members here unless they have a brief to do so, but at some point the leader of the DUP might want to rise to this challenge and say, well, what does he want the government to do?
I get the feeling Jeffrey Donaldson doesn't know what he wants to do, let alone what the government wants to do, because I've never known what the hell they want to do either, but that's my thoughts.
How else, and that's also the question, how else are you going to bring about power sharing unless you do something? Anyway.
Well, let's move on to Baroness Alone.
Thank you, Lord Chairman. I think to some extent we have been discussing this for quite a while, but in general, what are the legal implications of the approach in clauses 2 and 3 of the bill, which remove the effect of excluded provisions of the Northern Ireland Protocol in UK law and connect to parts of the withdrawal agreement? And if I could perhaps ask Professor Elliott to start.
Thank you. So I would say that clauses 2 and 3 are pivotal, and they're really sort of key to how the bill operates, because they provide for this concept of excluded provisions of the protocol, and they tell us what does it mean in domestic law terms for a provision to be an excluded provision. And what clause 2 in particular does is, very cleverly, it really unpicks carefully all of the things which I outlined earlier. So I explained at the beginning of the session that Article 4 of the withdrawal agreement itself not only requires the UK to give effect to the protocol and the agreement, but to give a particular kind of legal effect to the protocol and the agreement by really re-importing these European Union law concepts of direct effect and primacy, meaning that at the end of the day, if a provision of the agreement or the protocol was to be found inconsistent with an Act of Parliament, a domestic court would be required to give effect to the protocol or the agreement in preference to the Act of Parliament, just as courts used to have to do in relation to EU law. And all of that is provided for in Section 7A of the EU Withdrawal Act 2018. And so effectively what Clause 2 of the bill does is it removes all of that machinery from parts of the protocol which are designated by the bill or by ministers using delegated powers under the bill as excluded provisions. And as soon as a provision becomes excluded by the bill or by ministers, none of those special legal consequences apply. Section 7A of the Withdrawal Agreement Act falls away, and that then becomes inconsistent with what Article 4 of the Withdrawal Agreement requires, subject, of course, to the question whether or not the Withdrawal Agreement really requires that, because if we've derogated from it lawfully, then it doesn't. But leaving that point to one side, it's really sort of dismantling that special legal machinery that has been constructed to give the special legal effect that the agreement and the protocol need to have in domestic law.
Thank you. Professor Boyle?
Yes, I agree with that entirely. I mean, you would have to do something about the primacy of European law. And it's the same point with dispute settlement. You know, if this ends up in the Court of Justice, they will say that the protocol is European law and therefore it has exclusive jurisdiction to hear the dispute. And they'll ignore the arbitration provisions. They've done that in investment treaties. They did it in a law of the sea dispute where I was party for the UK and Ireland was the other party. And the Court of Justice said, no, you can't have this as an arbitration. This is for us to decide. That was actually good for the UK because it meant the arbitrators threw the whole thing out. But you know, you have to reach into the heart of the EU's legal architecture here for the whole thing to work. And Professor Elliott has set that out perfectly, and I entirely agree with him.
Thank you very much.
Thank you very much. Thank you. Lord MP.
Good afternoon to the two professors, and thank you for being here. Removing the requirement for Northern Ireland to apply EU law on customs and goods regulations for qualifying movements of UK or non-EU destined goods and introducing a dual regulatory regime for goods, what are the legal implications of the bill's provisions for those two areas? Professor Boyle.
I wonder if I could leave that to Professor Elliott. He may know more about it than I do.
Professor Elliott, you've been passed the ball whether you want it or not.
Well, I'm not sure that I do know more about it. I think I wouldn't want to go beyond what I can really talk about with authorities. So I think I would make a more general point, if that's acceptable, which is to say this. It seems to me that those are significant changes, and that they're not merely marginal changes to the protocol. And I think that there's been some disagreement about that. I was looking at what
I've been looking at the chat, and to be honest, see, we've just come back. Sorry about that, I don't know what I'm there. But do I just get the feeling that when he said, I'll pass the book here, and he said, I'm not really sure I could be much help either. I don't watch these two. I just thought to myself, what's the point of these two? But I do find a couple of stuff that they said quite interesting. There's one
different people had said about this kind of thing before coming along today. On the one hand, for instance, the former Prime Minister, when the bill, I think, was first published, said that it was a relatively trivial set of adjustments. In contrast, my Cambridge colleague, Professor Catherine Barnard, a professor of EU law, has said that the bill drives a coach and horses through the protocol. Now, I don't think that I'm fully qualified to say exactly where things lie between those two points, but it does seem to me that it is difficult to justify the view that the former Prime Minister adopted, that it's merely a trivial set of adjustments. And I think that the government's position, whereby it claims that the protocol as it stands is causing problems that are so grave as to allow it to invoke the principle of necessity, really sits in tension with that narrative that these are just very minor technical changes. So in terms of the scale of the changes, compared to what the protocol requires, it seems to me that they go well beyond the way that the former Prime Minister described them.
Remember when we did a video about Catherine Barnard on this sort of stuff? She was very good, wasn't she? I remember the name now, yeah. Catherine, she was very, very good.
Thank you for that. If I could just suggest to you, are you saying or suggesting that the government is acknowledging when it produced the bill that perhaps its negotiation negotiating strategy initially with the withdrawal agreement wasn't perhaps as good as they felt it was or said it was at the time?
Well, again, I'm not sure that I'm fully equipped to comment on that, but what I can say is that in thinking about whether the doctrine of necessity could apply, one of the criteria which would have to be satisfied in order for it to apply would be that the state invoking it, the UK, not be responsible for the situation that it's now trying to address. And I think that the government's argument in its legal position paper implies that is met, that condition is met, because it says that the protocol is being applied in a different way from it anticipated. But in fact, if you look at official publications from the government in relation to the EU withdrawal agreements, including the government's own impact assessment, it seems difficult to me to justify the view that the government has somehow been caught entirely by surprise by the situation that it now finds itself in. So perhaps that's a long-winded way of saying that my answer to your question is perhaps yes.
Could I tempt you, Professor Boyle, to make a comment on that sort of?
Well, in a sense, I'll comment by asking a question, but it's the question that I asked the economist very quickly outside, and maybe I got the answer wrong. And please tell me if you think I'm talking nonsense. But you will have read in the paper, steel imports to Northern Ireland, something 25% tariffs. Now, I did a quick Google as to whether Harland and Wolff is still in business. Well, it is, not building super tankers, but they're into heavy engineering and so on. So they need steel. And the aircraft industry needs aluminium. So what's that going to do to those industries which are utterly, which historically have been part of the Anglo-Scottish economy, if I can put it that way? It's certainly not going to help them. And if these provisions take away EU customs duties, then I would have thought they'd be delighted. And that's more or less, I think, what the economists said. But if they said something different, then maybe I have misunderstood them. That's possible.
Thank you, Chair.
Thank you very much. Thank you. Lord Dodds.
Thank you, Lord Chair. And I just wanted maybe to tempt both of you to comment then on a couple of other provisions, if you would care to do so, which relate to state aid and application of VAT, which are things that aren't sometimes talked about in relation to the protocol. It tends to be all about trade and customs and SPS rules and so on and so forth. But the fact that Northern Ireland is subject to the EU state aid regime, and the fact that, for instance, we couldn't benefit, our companies in Northern Ireland couldn't benefit from the reduction in 5% VAT on sustainable energy, which was announced by Rishi Sunak some months ago. So there is provision in this bill to take Northern Ireland out of the EU state aid rules altogether, and also to give ministers powers in relation to VAT. So I was just wondering, what are your thoughts on those particular provisions, Professor Boyle?
I would have thought, if I was a Northern Irish politician, I would absolutely want those provisions to be eradicated. You only have to look at the Northern Irish economy and the aircraft industry, Short Brothers, for many, many years, sustained by state aid. The shipyard, sustained by state aid. I would hate to have to run the Northern Irish economy with, if we couldn't ask Westminster to come up with some subsidies every so often. So you absolutely need to get out of these state aid controls if you're to give. I would have thought, anyway, I'm only a lawyer, but I would have thought, given Northern Ireland's economic history, it would be madness to remain subject to state aid provisions, and that if I were a Northern Irish politician of any political persuasion, yes, I would be wanting a derogation on that precise point. And VAT, well, again, I haven't thought that one through, but would you want different VAT rates in Northern Ireland from everywhere else?
The question, sorry to interrupt, but the question is, what are the legal implications of it, not so much the political ones?
Well, again, I think it's simply, you come back to the same question. Is this part of the price you have to pay to get the DUP back into power? Now, I mean, I wish I could...
Did he misspeak there? Did he say about getting the DUP into power? Is that wishful thinking, or is he just misspoke there? A dodgy thing to say.
Say, not DUP, but all of the Northern Irish parties. I wish they'd all get together. But supposing all three of them got together and said, you must derogate, otherwise we're going to collapse power sharing, then I would say they're right. I'd be with them. Because if this protocol is destroying power sharing, then something needs to be done about it. And as I look at it, reading the newspapers, it seems to me it's a reasonable conclusion to say it is destroying power sharing.
Yeah, well, I suppose when you look at the Belfast Agreement, which we refer to, which is the prior sort of treaty in all of this, and as you say, Professor Boyle, and Professor Elliott said as well, it's referenced in the protocol in terms of upholding it. I mean, all the institutions of the Belfast Agreement at Stormont, the East-West institutions, the North-South, none of them are operational. So it's hardly protecting the agreement. But Professor Elliott, if I could ask you, what I mean, maybe it can tempt you to talk about the legal implications of those state aid and VAT provisions, I mean, and how they fit within sort of the Article 16 approach, if that were the basis that the government were to use.
I don't think that I can really add usefully to what to what Professor Boyle has already said, and I think the extent to which they fulfil the criteria laid down in Article 16, in a sense, is not a purely legal question. It would depend on an assessment of the economic, for example, implications of those provisions, which I don't really have any special expertise on.
Thank you.
Thank you very much. I think Lord Godson had a question, then we move on to Lord Thomas. Lord Godson?
Just very quickly, just want to pick up on Professor Boyle, just want to understand absolutely correctly. You said you disagreed with the idea, was it that Article 16 was a violation of international law? You said you didn't consider that to be. I'm just trying to recall in your opening statement what you said.
Well, no, I think what I was talking about, I'm sure the chair will correct me if I got it wrong, but was that I said some people have said the bill is a violation.
That's it. Would you just go in some where you would dissent from some of the commonly expressed reservations of that kind? Just a little more detail on that.
Well, I've read quite a lot of politicians making that sort of statement, and I don't understand where they're coming from at all. None of them has set out a legal argument, presumably because they don't have one. They're probably not lawyers. But, there is no legal argument for saying that the bill is a violation of international law. What the bill does might or might not be a violation of the protocol or the withdrawal agreement, but that then simply takes you back into Article 16. If it's not a violation, if it's justified by Article 16, then there's no violation of the protocol, there's no violation of international law, and we're acting perfectly lawfully. No matter how often politicians in Brussels or elsewhere jump up and down, we're still acting lawfully. And they would be acting unlawfully to do anything else. And I noticed, I think I'm correct, I think I read that the UK has actually started proceedings against the EU for squeezing us out of the scientific cooperation programmes. And they're right to do that, because the EU has no right to take any kind of sanction against us. But I should also say, because this is probably obvious, but really this isn't a legal problem at all. It's a political problem. The people in Brussels don't want us to do it. The man in the White House doesn't want us to do it. Surprise, surprise. But they haven't got a legal argument that they can use. Theirs is a policy argument. And our response is we're entitled to do it. And that, or our response should be, we're entitled to do it under Article 16. But nevertheless, politicians, it's not sometimes wise not to push your legal rights to the full. They will have to continue to have relations with the EU and the Americans and the Irish. So, the politicians need to think carefully about how they're going, where they see this all ending up. But at the same time, how else do you put power sharing back on the road? That's not, and you call in Senator Mitchell again. He is still alive, but he's now very elderly. He's probably had enough of the Northern Irish. But that's not an easy challenge. But it's a challenge that, to my mind, and I'll emphasise here that I am Northern Irish, but to my mind, as somebody who's Northern Irish, restoring power sharing is infinitely more important than our relations with the EU or the White House. The White House is not going to bomb us, I think. But, this is not a trivial objective. This is a very, very important objective. We've,
well, Lord Thomas, let's move on to you to the last question.
Thank you, my Lord.
Article 16 is the part of the architecture of the protocol. It's the pressure valve.
Yes,
that's
a very good way of putting it, yes.
It's designed to resolve disputes through a process set out in Schedule 7.
Yes, that's right.
And it's an ongoing process designed to reach agreement. But the government haven't invoked it.
I don't know why.
I'm going to suggest a reason, because at the end of the Article 16 process, in the event of a disagreement on the law, you go to the European Court to determine it.
No, you go to arbitration with respect.
Well, arbitration, but from arbitration you go to the European Court.
No, that's not the way it goes. No, it's definitely, I checked this. It would be any dispute over the interpretation or application of the protocol goes to arbitration. The arbitration is binding on both parties, and the essence of arbitration is there's no appeal.
Well, there you are. And I had believed that the reason why the government won't use this pressure valve, this procedure, was that at the end of the road was the European Court.
Well, then somebody has misread it. What is true is that the Court of Justice itself would say it is jurisdiction over the dispute. So it could be that the EU would go to the Court of Justice, and the Court of Justice would say it's EU law and we have jurisdiction, but that's why we've derogated. That's why our derogations exclude the Court of Justice, and we need to keep hammering on at that. Any dispute about interpretation or application of the protocol, which means an Article 16 dispute, has to go to arbitration, not the Court of Justice, because we will lose in the Court of Justice. They will simply say it's EU law, us to decide, and we haven't got a judge there any longer.
Well, precisely.
So, that was an interesting conversation. Who's right? Judging by this, Professor Boyle, I'm not totally convinced with everything he's saying. But, man, sure, I'm not a professor, so what do I know?
Professor Elliott, do you have a view on this?
So I think that the potential role of the Court of Justice is maybe significant. Not because I'm disagreeing with Professor Boyle, but because, of course, one of the derogations that one of the respects in which the bill seeks to depart from the protocol is in relation to the jurisdiction of the Court of Justice itself. So, Clause 13 of the bill says that for the purposes of the bill, any provision of the protocol or withdrawal agreement is an excluded provision so far as it confers jurisdiction on the court in relation to the protocol or any related provision of the withdrawal agreement. So what this means, as I read it, is that the court is not being denied, for domestic purposes, jurisdiction just over parts of the protocol that have been excluded, but it's being denied jurisdiction over other parts of the protocol as well. And the reason that I highlight this point, against the background of the question that you asked Professor Boyle, is that it seems to me that trying to exclude the jurisdiction of the court in relation to parts of the protocol that have not themselves been identified by the UK as so problematic as to require being treated as excluded provisions is very difficult to justify, not just under the international law doctrine of necessity, but also by reference to the criteria in Article 16. So I think earlier Professor Boyle considered the question of whether all of the respects in which the bill seeks to deviate from the protocol could be shown to be necessary for the purposes of Article 16. And it seems to me that that's a respect in which the government would be on particularly shaky ground.
Do you agree with Professor Boyle that the European Court would have no part to play in anything to do with Article 16, such as to determine a legal point involving EU law that arose in the arbitration, which is part of the process?
I defer to Professor Boyle on that point. He has much greater expertise on this than I do.
Yeah, it rather depends on the arbitrators. But can I say, I entirely agree with what Professor Elliott said about the Court of Justice. That was a very helpful answer, if I may say so. He has addressed issues that I have no expertise in. But I think the key point, yes, he's right. How can you say that that derogation, the one that Professor Elliott has been talking about, is necessary for the restoration of power sharing? That looks to me very much like a Brexitish derogation, and that would be much more difficult to defend. But defending the proposition that disputes on interpretation or application of Article 16 should go to arbitration, that I think is much easier to defend, but that is there's a long history of the EU refusing to arbitrate under investment treaties or under the Law of the Sea Convention, trying in effect to torpedo an agreed dispute settlement regime, and then you do have a problem. I don't know where you go if the EU tries to do that here, but
you did say to me that the EU would apply to the European Court, and that the UK would be in a difficult position if they did.
Well, I suspect they will.
EU would apply in what circumstances? When the arbitration failed, or a point of law arose, or
that's a hard one for me to answer. My expectation, my feeling is that they would, but I can't really answer it. I don't know whether Professor Elliott wants to rise to
They
that.
wouldn't make an application unless the European Court had jurisdiction.
Oh, well, that's simple. They would say this is all EU law and we have exclusive jurisdiction. Arbitrators don't. That's what they've said in investment cases. That's what they said in the Law of the Sea case involving the UK and Ireland. So they've done that already. That was the Commission, that was the court in UK and Ireland, the Mox Plant case. I know because I was on the UK team.
And who won?
Well, actually, we won because since the court had exclusive jurisdiction, the arbitrator said we can't arbitrate. Now, that's a risk here. We could go to arbitration, and the EU might turn up and say, "Oh no, the Court of Justice exclusive jurisdiction. This is not for the arbitrator," and the arbitrators might throw up their hands and walk away. On the other hand, there's a recent arbitration called Rockhopper Oil. Rockhopper Oil, I think, operates from Edinburgh, and they had a concession to drill on the Italian continental shelf for oil, and the Italians, in deference to their climate change obligations, have said no more drilling on our continental shelf. So they revoked Rockhopper's concessions, and the arbitrators rejected the EU argument. as far as I can tell. It's a long case, and I haven't yet digested it in detail, but on a quick reading, they rejected the EU argument that they had exclusive jurisdiction. So it may be the tide is turning against the EU, but there is a risk. Arbitrators might say, Court of Justice exclusive jurisdiction.
This is in an Article 16 situation.
Even in an Article 16 situation, yes.
So it's possible that the European Court could be the ultimate decision maker.
Yes, it is possible.
Under Article 16.
You know, you might think it bizarre that they find themselves sort of the ultimate arbitrators in a law of the sea dispute. Well, they did.
Yeah.
Let me just ask whether Professor Elliott has anything to say on this.
No, I don't want to add to what Professor Boyle has said on this point. Thank you.
Good. Well, thank you very much indeed, both of you. Is that it? Yep. Thank you very much indeed, both of you. It's been extremely helpful to us.
Well, that was interesting, wasn't it? I noticed one or two of you not a fan of Professor Boyle. But yeah, there was some good little chunkies in there. There were a couple of bits when I've forgotten the other guy's name now, where he talked about Catherine Barnard. Remember we did that little video? She talked a lot of sense, didn't she? And talked about coaching horses, and the other guy seemed quite more forthright and seemed to make much sense. I just found Professor Boyle sometimes, is he contradicting himself? Painful, more interesting. Jeez, rather, the professor, he must work hard because he's. By God, over under a four. By God, I'm surprised. Under a four, only 40. Oh, well, thank you. Okay, so how to read? No, you're an idiot, and this is a stupid idea. Yeah, some of the stuff he was saying, I would think to myself, not sure I agree with him there, but sometimes they say professor before the name, you think, well, I'm not really going to have an argument with you because chances are you probably know more about that than me. But I did think there were times where I was thinking, he seems to be contradicting himself. But yeah, it was, I've got to say, I'm really sorry for having you all waiting. I really, really do apologise for that, because I'm such an idiot sometimes. Oh, I recognise what I did wrong, and I will do my best to rectify it. And chat to Professor Boyle was a waffler. Yeah, he did seem to waffle a little bit, didn't he? Yeah, he was, and a lot of the times I was thinking, I'm not right sure. I think even he knows what it. Yeah, I remember. Yeah, I got the feeling that little bit as well, where he says it looks as if Elliott doesn't want to offend Boyle. I get the feeling there was a little bit of that, especially in the end bit when Lord Thomas, they were having that little bit of a set too, and I got the feeling that I think more Lord Thomas was more right than Professor Boyle. Yes, I love how it was. The EU will take it to their courts. When how many meetings have the EU held with the business leaders, etc., to try and fix problems with? Yeah, totally agree. I remember. Yeah, we're all fucked up. It's what you class as an eater mess, isn't it? Really, we are absolutely right up the shitter, aren't we? But yeah, that's him saying that no, it goes to arbitration. only if the EU agree to the terms. They literally have to sit down once and say that this isn't tenable. To courts we go. Well, yeah, it does seem like that. Yeah, but as I say with Elliott, you got when we got talking about the conversation, I got the feeling he disagreeing with Boyle, but he wanted to say it rather nicely. But Uncle Sam will slap the hell out of the Tories if they break. Well, yeah. And I noticed his little chuckle when he mentioned about our friends over in America. Little chuckle. Something tells me I think he's bit more of a DUP fan than what he's letting off, especially when he said, talking about, when he said that DUP getting back into power, you think, I think he... yeah, the Tories must go, then we might get somewhere. Yeah, right. Because, like, see, the thing is, even if the more and more we look at our system, I think we need proportional representation or something, though, because under this system, say if Labour gets in next, what's to stop Conservative getting in after that, and say if during Labour we rejoin, even though I have my doubts, because why would you want us back? Especially after this, if you know that within 4 or 5 years of Tories coming back in. Jesus Christ. On state aid and VAT, you cannot cherry pick. If you want to ditch those, you ditch access to EU markets, which is far more viable to Northern Ireland. Yeah, that makes sense. Is that what you do, Duke Vengeance? Expertise in finance. Trying to scrutinise documents and be accurate. I've got to say, you're a better man than me. When it came to numbers and stuff like that, when I went to school, my brain wouldn't allow me to understand them. But I noticed in the chat, Duke Vengeance, there were a few times where I got the feeling your blood was boiling. which understandable. Sorry if I put you through that. I do apologise. But you guys only need to, you guys only need to say, and that I mean English populace at large. Well, yeah, it just shows you how ridiculous. You've got a guy in there like Lord Hannon. Oh. He's in one of these meetings. I won't trust him to run a bath. He just, yeah, exactly. PR must be the job. One for any Labour coalition government that gets in, or anything done will be later undone. Yeah, you can just say it, can't you? Even Charlie accepts DPR number one in Northern. Did you say that? I thought it was quite funny. Chuckled away. Yeah, I can imagine Duke Vender's not amused. Sorry for putting you through that. I do apologise. I really do apologise. Hold on. Yeah, the UK took on Little Ireland in a trade war. It ended with the UK losing 3 treaties, ports and their fortifications that were considered UK sovereign territory. Wow. Dear, how embarrassing. Well, yeah, I think we are. Well, yeah, you do. You've got a point there. UK does not vote Tory. England does. They need to wake up before the kingdom's gone. Well, to be honest, I don't think they will. Well, yeah, I'm disagreeing with myself there. I do get the feeling strongly that there are a few people who are starting to see the light. Whether there's enough, I don't know. Here's what's going to happen. They'll allow some chemical to be fed to cows in UK, which is banned in the EU. Irish milk sold in UK will go up 50p a litre and sell 10 times as much. Won't surprise me. Do you know, I remember when you I'm doing sexy dancing with my mic there. Sorry about that. I'll tell you what it reminded me. It was, it just reminded me of when, not long after the referendum result, I had a few people on Facebook, but they're all high-fiving each other, you know, thinking, yes, we've saved the country. And I remember somebody put in one of his comments, thank God now we can get back to buying fish and chips for £1.50. You think, I kid you not. The only reason why I kept that in mind, because I just looked at it and I just looked at the comment, then looked at it again. And it also reminded me of the time not long after, you know, when everybody's piling in, the pounds tanking and everything's turning to shit. And everybody who voted Remain said, are you concerned about what's happening? The pounds tanking, everything's good. Somebody wrote, I don't care if I'm poor, I just want my country back. And you just think, how can you reason with somebody as stupid as that? I think we should. Yeah, that's something I found quite annoying. Stop blaming the Tories. The last Labour government, neither. The Tories are still blaming the last Tory government, neither of which will go for PR. Well, yeah, it's I find it a bit grating when, you know, they're talking about something that was done under a Labour government. You think, well, you've been in power for 12 years. You've got an 80-seat majority. What you can undo these horrendous rickets that this last Labour government did. Fucking idiots, aren't they? Yes, fucking Hannon. Totally agree. Yes. Argument. Oh, just saw. I can't see what it was. Somebody put fish and chips for £1.50. Yeah, I kid you not. I'm not jesting with you. I was totally stunned, and you just think, yeah, that's what he wrote. Get back to having fish and chips for £1.50. You think, do vengeance. This is what I had to drink. Yeah, you and me both, mate. I totally agree. It's like, even now, if I bump into one or two, I know void leave if they bring up, and one or two of them still, and I just shut them down. I just say, you won't get over it. Why are you talking about Brexit? Brexit's been done, apparently. It's like, it's like, there's no point trying to reason with these people. They just don't care. A pint for a pound, yes. If only. But you try and have a conversation with these people, and it's all deep-rooted down with immigration. You try and have a reasonable conversation. More often than I'll say, I've just got to go, my wife wants to see me. And I just blows my head off. Yeah, pint for a pound, if only. Yeah, if only. I was born in 1971, Liam. So I remember as a kid, me and my grandma and granddad, they used to run a club. It's just down the road from where because like where where I live now. This is my grandma and granddad's old house, so there's a picture of me in the front garden, you know, as a little toddler in a little baby walker, chomping on this duck's head, you know, greedy little so-and-so. And they used to run the club. I called it Idle Working Men's Club. And they used to sell a pint of blue for 69 pence. So they used to call it a pint of blue. My God, those were the days. I used to play pool in there. And that was before me. And I wasn't too bad, actually, until then my eyesight started to fail on me. And, but yeah, I had good times. I had some good times in there. It used to be 20 years ago. Saying, yeah, you're probably not far off, but yeah, as I say, we're at very early 80s, could have been 80 to 82, 3. My mum used to help clean in the morning, and I always used to look at the prices, because it's like my maths I was terrible at maths. My brother, he was more of a whiz at maths. So what they used to do was, you know, they'd have me stood at the bar and they'd say to me, pint of blue, pint of best, da-da-da-da. How much does that cost? And I'd start to like get used to how much it would be, £1 something, da-da-da. And say, yeah, nice one. Yes, I totally agree with you, Liam, yes. Saying out about the 70s music. Good bit of Hawkwind. I loved a bit of Hawkwind, yes. Some good stuff in the 70s. Right. I suppose in a way, what time is it now? Well, it's nearly 10:15, and it's on a Thursday, and so I think we've pretty much tired out this live stream now, haven't we? So, and all I can say is I just want to apologise for absolutely making a train wreck of this at the start. You all sat there for an hour. I'm surprised you hung around. But thanks you did anyway. I'll get this live streaming right in the end. Believe me, I will do. But yeah, I just want to... I translated the pint into a pound of mils into the price of a pint is over €5.60, and I don't drink enough. Jesus Christ! We've got a pub in town. We call it the Shoulder and Mutton. It was a Sam Smith pub. We used to get a pint of taddies for £2.16. That would be before COVID. After first day we walked in, everything changed. It was nearly enough £4. What made it even worse, I used to like going in there for a pint of Sovereign, beautiful pint. So I said, "Can I have a pint of Sovereign?" She went, "Oh, we don't sell it anymore." I went, "All right, see you later." Off we went. But never mind. Right, anyway, I think we've exhausted this live stream now, so I just want to say thank you for hanging around, and I'm sorry for earlier on. I will get this live streaming malarkey proper sorted, and yeah, probably is right. In a way, I sort of like, well, then I just thought, right, I'll have a look at what's happening on my YouTube. Then I noticed it went on. I thought, you tit. I just thought, you idiot. What are you? What a belt up, but never mind. But anyway, I will ponder to get it right. I will get it right. And, I'll say thank you for joining me. And hopefully to see. Oh, before I go, I've got one or two ideas for a for another live stream. I might do one Monday. Because something tells me you're a little bit like me. I don't think you'd be that interested in the what you call it, the funeral. It's not my thing. And something tells me, I get the feeling some of you will have similar emotions as me. But I probably might be tempted to do one on Monday. Bit of a change of scenery, because I was going to do like I did on last Saturday, where we just had a bit of funny videos and a bit of a giggle and a laugh. Does it involve nudity? Unless you want me to. No, I've a body of a model of milk. That's and I won't want to put you off that. But like I did on bit of a giggle and a laugh. I was going to do it Saturday, but got to go at football Saturday and Sunday. A friend of ours has invited us out for a couple of beers, so I might do it on the Monday, because I'm not really interested in watching the funeral. It's not my thing. I don't know her, so didn't do anything for me. So, but anyway, I'm chuntering on. So I just want to say sorry for earlier on. I will get this right, and I will get it spot on. So I just want to leave it here, and until the next time, I shall bid you farewell and take care. Tatty bye.